All rise. We will obey. The International Criminal Court is now in session. L'audience de la Cour Pénale International est ouverte. Please be seated. Veuillez vous asseoir.
Thank you. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. And we're in open session, Your Honors.
Thank you very much. Appearances, please.
Good morning, Mr. President, Your Honors. Counsel opposite, counsel for the victims. My name is James Stewart, Deputy Prosecutor, appearing for the prosecutor, along with Anton Steinberg, Senior Trial Lawyer, Counsel Rod Raston and Thomas Bufole, and our case manager, Yasmina Sulyanovich.
Mr. Nderitu.
May it please Mr. President, Your Honors, I am assisted in this case by Mr. Ochlon Narantsetseg, who is from the OPCV, and Mr. James Mawira, my case manager. Thank you.
Good morning, Mr. President, Your Honours. Mr. Ruto is represented by Mr. David Hooper of Queen's Counsel, Ms. Lee Laurie, Legal Assistant, and Ms. Shalini J. Raj and Ms. Grace Sullivan, who sits behind. Your Honours, my name is Kareem Khan.
Good morning, Your Honours. Mr. Sang is represented myself, Katwa Keegan, Caroline Busman, Logan Hambrick, and Hona Lanham. Mr. President, may I mention that we had requested to dispense with Mr. Sang's presence in the status conference, and it should be available after 1 hour that the status conference was said would last. Thank you, Mr. President.
Fair enough. Now, we will finish the status conference we started on Friday. We want to be done with it by 10:30 this morning. We will like to hear from Mr. Nderitu before you begin, so that we can focus the discussion. There are two issues, although related, but can also be seen in their separate elements. One is whether the chamber has the power to compel a witness to appear. As a general proposition. The second question is whether, assuming the chamber has the power to compel a witness to appear, as a general proposition, whether the chamber can create either a duty or a legitimate expectation on the government of Kenya in particular, not any other state at large, the government of Kenya, to assist with compellability in the circumstances of the prosecutor's request in this case. In order to focus the attention, let us forget about the first part of the question, whether or not there is a duty to compel a witness to appear as a general proposition. But let's not waste time with that. The Attorney General was quite wise to concede the point. So let's focus on the second one. Thank you.
Thank you, Mr. President, Your Honours. With regard to the second question, that is, whether, assuming the chamber has the power to compel a witness to appear as a general proposition, whether it can create a duty or a legitimate expectation on the government of Kenya in particular. This is what I would have to say. That first and foremost, it is very clear under Section 86 of the International Crimes Act and also Section 108 of the International Crimes Act that it is more than just a discretion that arises on the part of the Attorney General once the provisions of Article 64, sub-Article 6b, have been invoked. And it is very interesting to note that
When you say it is more than a discretion, do you mean it is a duty on the Attorney General?
Yes, absolutely, my Lord. Under Section 86, and permit me, please, to read out, 86 subsection 1 says, where the ICC requests assistance under paragraph 8 of Article 19, Article 56, paragraph 7 of Article 58, Article 64, or paragraph 1D of Article 93 of the Rome Statute, in arranging for the service of a document in Kenya, the Attorney General shall give authority for the request to proceed if he is satisfied that A, the request relates to an investigation being conducted by the prosecutor or any proceedings before the ICC, and B, the person or body to be served is or may be in Kenya. So what we're saying here, Your Honor, is that as long as the two conditions, that is, having a relation to proceedings before the ICC in this case, and the person or body being served being or may or perhaps being in Kenya, then the Attorney General has a duty to accede to a request by the court. It's very interesting that what I hold here before you, Mr. President, and Your Honors, is the copy of the International Crimes Act as printed by the government printers. And for the first time, I see that the initial wording was may. Instead of the Attorney General shall give, it was the Attorney General may give authority. And then that was cancelled into a shall, which is not just a shall, but a shall in bold. And I have also taken time to look at the electronic version of the Act from the official law reporting institution of government. And again, it also has a shall in bold. It's very telling.
Wait a minute. Did you say that both may and shall do appear, but may is cancelled out in the version you have, as in stricken out?
Precisely. It's stricken out, and then shall does not just appear in ordinary print, but in bold print.
Right. Can you kindly make available a copy of what you're referring to, because the
yes,
version,
I will.
The version I have, which is, it's like you may have been downloaded from the internet. I don't know who was kind enough to compile this volume.
The one downloaded from the internet, Your Honor, is still, it has shall, it does not have may, but it has shall in bold still, which is very interesting again.
The one I'm looking at here, actually, there may be different versions.
Okay.
The one I'm looking at has may, not stricken out, but shall in bold.
Very well,
As I say,
yes.
this may not be the authoritative version. It looks like the one you have looks like the authoritative version published in the Gazette, he said.
Okay. Yes, I will make this available. If we look again at Section 108, we find an elaborate procedure, again, in connection with requests for other types of assistance. And this is under Article 93(1) of the Rome Statute. And again, the two main conditions to be satisfied are that the request relates to an investigation being conducted by the prosecutor or any proceedings before the ICC, and the assistance sought is in accordance with Kenyan law. And it is noteworthy that under subsection 3, if the Attorney General considers that the assistance sought cannot lawfully be provided, he shall, before refusing the request, and in accordance with paragraph 5 of Article 93 of the Rome Statute, A, consult with the ICC, and B, consider whether the assistance can be provided subject to conditions or whether it can be provided at a later date or in an alternative manner. The sum total of Section 86 and Section 108 is to make it very, very clear that the legislative intent is to give power to this court to make an order for the issuance of summonses, and that if there is any practical difficulty, then the Attorney General will have an obligation to consult with the court.
Senator, to hold that thought, please. For the completeness of the record, I'm bound to observe in relation to my last observation about what 86.1 says. I'm also looking at yet another version of 86.1, again, that was made available, and it only has the word shall in bold, and the may is not in it, does not appear in this other version. So there are different versions of the ICA. I just thought I should complete the record on that. Please proceed.
Yes, thank you, Mr. President. Yes, I have seen three versions myself. One electronic, which is a mirror image of the hard copy that I have, then the hard copy that I have, and then the one that does not have the word may, but has the word shall in bold. Thank you. Mr. President, Your Honors, it is a fundamental principle of statutory interpretation that a legislative body does not act in vain. And therefore, we must go back and ask ourselves why there would have to be paragraph B of subsection 6 of Article 64 of the Rome Statute if there was no intent to have the ability, for the court to have the ability to issue summonses. We must also go to Article 93 and look not only at the marginal notes, which talk about other forms of assistance, but also draw a distinction between 93(1)E and 93(1)L. And 93(1)L which is the catch-all provision, must then be looked at distinctly from 93(1)(e). And it is my submission, Mr. President, Your Honors, that the Rome Statute in Article 93 does recognize both voluntary appearance and compelled appearance.
On that note, looking at 93(1)(b), Article 93(1)(b), I mean, you there?
Yes, I am.
Article 93(1)(b), which contemplates assistance in the form of the taking of evidence, including testimony under oath. As far as you're aware, as a Kenyan lawyer, what we're thinking about here is it not, where a request is made for perhaps a judge in Kenya to assist with that process. Is that what we're looking at?
Yes, that is correct.
All right. In that event, can that judge, the High Court judge in Kenya who's assisting with the taking of the evidence, can he or she compel the witness to appear before him or her?
Yes, Your Honor. I have no doubt about that, because in the first place, under Kenyan law, in respect of criminal proceedings, with the fewest of exceptions, witnesses are generally compellable.
All right. Now, if that is the case, that a Kenyan judge taking evidence on behalf of the ICC can compel a witness to appear before her or him, do we see then any material distinction, any material reason for a distinction that would prevent the ICC, while convened in Kenya, to require the attendance of a witness and having Kenya assist in making that happen?
Mr. President, Your Honors, the only situations that I would see would be the same situations that would avail to a witness in a criminal case in Kenya. For example, if we are talking about spousal immunity, then obviously in a situation where the court seeks to compel the wife, say, of an accused person, the policy position goes against that, generally. But in the ordinary situation, there is no material distinction between the ICC operating in Kenya through a Kenyan judge and the ICC operating here. I do not know if I have made myself clear.
All right. What about ICC operating while either convened in Kenya or a witness situated in Kenya and being piped in, the testimony being piped in through video conference. Do you see a material difference there as well? Or none? Or is it the same?
Again, Your Honors, I do not see that there would be any distinction whatsoever. So far as I'm aware, there is no law that disallows the taking of such evidence in Kenya.
And we move now to the question of complementarity, the angle of it. Do we expect that the notion of complementarity would, as the doctrine is understood to operate, would put the ICC in a lesser position to compel the attendance of a witness, a Kenyan witness, when the ICC is exercising jurisdiction and sees of the matter? Would it be in a lesser position to compel attendance of a Kenyan witness than a Kenyan court actually trying an international crimes case would be in compelling the attendance of a witness before the Kenyan judge or the Kenyan court trying a case within the jurisdiction of the ICC?
Thank you, Mr. President, Your Honors. As I understand it, and adopting a very broad approach to the principle of complementarity, the court, that's the ICC, and the national criminal jurisdictions are appendages of each other. They are, so to speak, two organs which are part of one body. And the basis upon which I say that is that under our Article 2.6 of the Constitution, we recognize that every treaty that has been ratified by Kenya forms part of the laws of Kenya. But more importantly, in the case of the Rome Statute, we have domesticated the Rome Statute through the International Crimes Act. So from that point of departure, while it may be said from a factual point of view that the ICC could play a lesser role, when it plays a lesser role, then the Kenyan legal system must play a greater role. That is the way I would look at it. That's the concept of complementarity. So that if we're saying that the ICC will play 10%, the Kenyan judicial system must play 90%, or Kenyan legal system in general must play 90%. Where the ICC plays 40%, the Kenya legal system must play 60%. Because the idea is to assist the doing of those acts that Kenya as a state party would not either be able to do or would be unwilling to do. That's the way I would look at it.
But when the ICC does play its own role, sees off a case because the test for admissibility has been passed, would it be in a lesser position to do justice in the case in terms of the powers the ICC must have then would the Kenyan court seize of the case genuinely? If you don't understand the question, I can rephrase it.
Yes, I would appreciate it. I would appreciate it.
My question is this, so that we clear out the matter. Complementarity gives the primary jurisdiction to the state. So if in the best world the state is trying the case, the courts of that state would have power to compel the attendance of witnesses. Is that not the case?
That is so, Mr. President.
If the state is not trying the case, and ICC is trying that case that the state ought to have tried, will the ICC not also have the power to compel the witness to appear, just like the state court would have had if it was trying the case?
Precisely, Mr. President. That is what I was saying, that it's something akin to the principal-agency relationship, or what in the law of torts and that we call in Latin, qui facit per alium facit per se. That is, he who does an act through another does it himself. So we are saying here that if the state does not do something which is required by the Rome Statute to be done, then the court can do it. Or if the state does not do something that is required by the International Crimes Act to be done, in respect of a matter that is pending before the ICC, then the ICC can do it.
And the ICC would have the powers to do it, the full powers to do it, than as the state would have had to do it, the state court would have had. Is that what you're saying?
Absolutely, absolutely, absolutely.
Another question for you is this. Moving away from complementarity now. In a case of theft, in Kenya, for instance, criminal case of theft, from what you've said, it would seem that with the exception of the spousal privilege and things like that, a criminal court sitting in Kenya would have the powers to compel a witness to attend in a case of theft. Is that correct?
Yes, that is so, Mr. President. And in fact, my argument is that if in a case of simple theft, the criminal court sitting in Kenya would have powers to compel, then
Now, if that is the case, do we see any reasoning by which it could be that if the same court, if a court in Kenya is sitting in a genocide trial or trial of crimes against humanity, it would not have the power to compel a witness to attend? Do you see any theory by which we can arrive at that conclusion reasonably?
Not at all, Mr. President, Your Honors. As a matter of fact, the Rome Statute is very, very clear in its preamble as to the purpose for which the ICC was established, and that is to end impunity. And there would be no logical reasoning in law if it were possible to compel in respect of a witness in respect of a very, very light offenses and not be able to compel in respect of offenses which, as they say, shock the conscience of man.
Those are my questions to you. You have 2 minutes if you want to make any more additions. 2 minutes.
Thank you, Mr. President, Your Honors. It was suggested that it is only the office of the Attorney General, and this is I'm looking at the submissions made by the Attorney General of the Republic of Kenya, that it is his office that is entitled to get an interpretation for the purpose of this court. And with due respect, the position that obtains is not that only the Attorney General can give an interpretation. And in fact, the interpretation of the Attorney General with regard to what the state of the law is subject to a judicial determination. As a matter of fact, the Attorney General, in matters that relate to interpretation of the law, more often than not finds himself in the same position as any other litigant, and then the courts determine what the position is in case there is any dispute. But having said that, my respectful submission is that with regard to Article 64, Subarticle 6, Paragraph B, and the whole of Article 93, Subarticle 1, I do not find that there are sufficient grounds upon which to say that there is serious dispute with regard to what is required of this court and what this court has power to do, what duties obtain vis-a-vis the Attorney General in a situation where this court may grant a request by a party for the summoning of witnesses. I think that is what I would want to say for now. Thank you.
I've consulted with my colleagues, and we may be able to continue until 11. We had indicated earlier that we would stop at 10:30. That being the case, is there anything more you would like to add at this stage? If not, we can proceed with other counsel and, if need be, revert back to you.
Thank you, Mr. President, Your Honors. I think if I were to add anything, I would want to just recapitulate what Section 4 of the International Crimes Act says in terms of the Rome Statute having force of law in Kenya. And I think it's very, very clear in terms of the applicability of Part 6 of the Rome Statute, in which Article 64 finds itself. Yes, in connection with conduct of trials. That's one of the things that I would want to really bring out. And I perhaps should also want to highlight the provisions of sections 10 and 11 of the International Crimes Act. And section 10(1) says that a person who willfully attempts in any manner to obstruct, pervert, or defeat the course of justice of the ICC is guilty of an offense and liable on conviction to imprisonment for a term of not more than 5 years. And then the opening words of subsection 2 are important, and it says, without limiting the generality of subsection 1, a person shall be deemed willfully to attempt to obstruct, pervert, or defeat the course of justice if, in any existing or proposed proceedings of the ICC, he, A, dissuades or attempts to dissuade a person by threats, bribes, or other corrupt means from giving evidence, or B, accepts, obtains, agrees to accept, or attempts to obtain a bribe or other corrupt consideration to abstain from giving evidence. Then section 11 then says that a person who resists or willfully obstructs an official of the ICC in the execution of his duty, or any person lawfully acting in aid of such an official, is guilty of an offense and liable on conviction to imprisonment for a term of not more than 2 years. What am I saying here, Mr. President, Your Honors? What I am saying is that under Article 64(1)(b), if this court were to find it necessary to issue summonses against the witnesses in question.
64(6)(b), you mean?
64(6)(b). Yes. Then, thereupon, that becomes, under Section 11, something that is capable of being, or it becomes part of the execution of a duty of an ICC official or ICC officials, in this case, the 3 judges before us. And that, then, if any person obstructs that, that is, if one does not then invoke the provisions of Section 86 and the subsequent sections, and Section 108 and the subsequent sections, then that person becomes guilty of an offense and is liable to punishment upon conviction. That's the point that I am making.
Thank you, Mr. Nderitu.
Thank you.
We will now leave it there with you for now, and we will go back to the defense. And after your reactions, the prosecutor will
I'm grateful.
reply, and we will bring the proceeding to an end.
I'm grateful, Mr.
Mr. Khan, how much time are we looking at?
Your Honor, my learned friend was given, I think, about 34 minutes. I would say I will try to do it, well, it depends. I would ideally like half an hour. But
No,
I know
you will not get half an hour.
I understand that, Your Honor.
Your learned friend hadn't spoken before. This is the first time he'd spoken. You mean Mr. Nderitu, right?
No, Your Honor, I think he spoke at the outset. In
No,
total.
this is the first time he'd
Well,
spoken.
Your Honor, he's had 34 minutes. Your Honor, if I could have 15 minutes, I'd be grateful. And I'll try to motor. If I finish before, of course, I will endeavour to do so.
All right. 1 second. Mr. Keegan Katwa, you had also requested some time.
About 15 minutes, Mr. President, please.
Mr. Stewart, how much time would you need?
Well, 15 minutes will do. I might just say that Mr. Steinberg assures me that given the challenges that the team is facing with respect to witnesses, we needn't rush through the morning, if I can put it that way. There is some time. We have a witness, I understand, for today that will take several days, but in terms of your whole session, there are some difficulties. So if you're concerned about getting through the evidence that you're scheduled to hear, we can, entirely in your hands, be a little bit more relaxed, if you wish.
Well, we have all kinds of other work we must do when we're not sitting here. 10 minutes each. Mr.
Your Honor, I'll do my best.
10 minutes.
Your Honor, the old adage needs no repetition that hard cases make bad law. It's our submission that the prosecution's postulations ride a coach and horses through the provisions of Article 93, rendering redundant as they do all other sub-articles of 93 except L. Your Honours, in relation to the question about legitimate expectation, it's our submission that this concept does not come to the aid of the prosecution. The concept of legitimate expectation, of course, is principally a private law concept from English law. It's developed into the public sphere. But, Your Honour, it's a doctrine that finds its foundations in the rule of law, and that as part of the rule of law, certainty and predictability are necessary for the citizens of a democratic society. Your Honours, rather than assisting the prosecution, if the concept was to have any force at all, it would assist those individuals that refuse to cooperate with the prosecution opposite. Because there is a public...
Let's legitimate expectation. The question was framed in terms of either a duty or legitimate expectation. A duty or legitimate expectation, as you may well see. A legitimate expectation is the softer of the two. And let's not take it beyond meaning simply an expectation that is legitimately founded. If we can accept that definition, then you can proceed.
Well, Your Honour, it's always, and we know that from the whole basket subpoena issue, dangerous to transplant mechanically terms that have connotations domestically. But in relation to the concept of legitimate expectation, there is the International Crimes Act, which expressly states that individuals will only have to attend voluntarily.
And that could be the basis to argue that there is no legitimate expectation, if you can point to provisions of the International Crimes Act that forbid any expectation in that regard.
Your Honour, I won't repeat what the Attorney General says. The principle that everything is permitted, that it is not prohibited, does not come to the assistance of a state. It is primarily a right that pertains to the individual. And an individual has a right not to be arbitrarily arrested except through a regular law already in force. And I won't deal with non-retroactivity either in the time allowed. Your Honours, the prosecution have repeated in all their interviews, and the transcripts are there, I won't go into them, they've told all their witnesses appearance is voluntary. Yet what they, and indeed, Your Honours, they've even told domestic authorities like the Kingdom of the Netherlands, and I refer to the prosecution's tab E at Ken OTP 0116-0247, and I quote, "The father does not have to testify anymore." That's what the prosecution have told the Kingdom of the Netherlands. Yet despite that legitimate expectation, despite that undertaking, they come here and change their position.
Speak slowly.
Your Honour, in relation to the appropriateness of the subpoena, it would not have escaped the bench's attention that witness 15, indeed, has given an affidavit in which he said he is willing to cooperate, but what he says in Annex B is that he was willing to attend by video link from Kenya. The prosecution haven't apparently chased this affidavit. Their endeavours, it appears, are restricted to bringing him as a witness before the court. And so, Your Honour, on the principles of subpoena, even from the ad hoc tribunals, the prosecution have not made out a legitimate forensic interest. Your Honours, there is settled jurisprudence. We've heard a bit in the filing about academic opinion. But we have, and it can't be cast aside, because in the hierarchy of persuasive authority, it's the highest. There are 6 judges of this court, elected by the ASP, making decisions, not academically, but pursuant to their oath of office, that have unanimously said that there is no power of coercion. Witnesses must attend voluntarily. The prosecution are seeking...
What authority is this?
Your Honour, it's the Lubanga case, which appears at paragraph 20 of the Sang filing. And, Your Honour, it's the Kenyatta case, situation decision, of the 31st of January 2011.
No. What chambers are we talking about?
Your Honour, pre-trial chamber 2.
In what? In Lubanga?
In Katanga. In Kenya.
And in Lubanga?
And in Lubanga, it's the Lubanga trial chamber, trial chamber 1. Your Honour, the prosecution did not seek to appeal those decisions. Paragraph 20 of the pre-trial chambers 2 decision, ICC-0109, page 9, paragraph 20, makes it very clear that according to the statute, and I quote, the court may request a state party to facilitate voluntary appearance, but not to compel a witness to testify before the national authorities of a state. Your Honour, these jurisprudence from judges of this court cannot be cast aside simply because...
Can you slow down? You're speaking much too fast.
Well, Your Honour, it's very difficult to deal with an important issue in 15 minutes, so I'll endeavour to slow down. But I am also trying to rush to cover the areas in an important issue. Your Honour, the prosecution have made some play.
In those cases, Mr. Ken, was there any discussion of the ICJ judgment in the reparation case? You remember the ICJ judgment in the reparation case, reparation concerning staff members of United Nations?
Your Honour, there wasn't, to my knowledge. The judges were simply looking at the language of the statute in the first place, in accordance with Article 21.
Was there a discussion of the nuclear tests case?
Your Honour, no reference to the ICJ at all.
All right.
Reference to the statute, which, according to Article 21, of course, must be applied in the first place.
You remember what those cases said? The reparation case and the nuclear tests case, in particular.
On what issue, Your Honour? In relation to implied powers?
On the
or
matter of, 1 second, on the question of implied powers of an international body or institution.
Your Honour, I'm familiar with that. They were not discussed. As I mentioned, I can't possibly do justice to ICJ jurisprudence in the time allowed. I'm very delighted to brief you on it.
Please,
they're inapplicable
proceed.
in this case, and in our respectful submission, under Article 21, those authorities, in any event, must be applied in the second or the third place. Your Honour, the third issue I'll deal with is the prosecution seek to imbue Article 93(1)L with greater powers.
Now, before you proceed, when you get a chance to think about it, you might also want to speak to it. In the reparation case, the ICJ said that an international body or institution has implied powers that are essential for the execution of its mandate. That was a reparations case, speaking generally about international institutions. And in the nuclear tests case, the ICJ also said that a court, speaking in that sense, the ICJ, has implied powers to execute its jurisdiction as a court of law.
Your Honour, I'm familiar with those cases, but there's also the Vienna Convention on the Law of Treaties talking about the plain language and in good faith. In our respectful submission, of course, an argument can be put forward that would contrive, we say, to get the results the prosecution wish. But that would be to contort the plain language of the statute in bad faith, because it would be reflective of a results-orientated approach, not one based upon honest assessment of the statute and the travaux préparatoires and the objectives of the instrument.
Now, can you focus your attention now on whether the ICA or any provision of a Rome statute says that the chamber may not either respect or create a duty on the government of Kenya to compel a witness to attend. In Kenya,
Yes.
with the court convened in Kenya, or the witness situated in Kenya and the testimony is taken through video link.
Your Honour, 93(1)(e), we say, forbids the court requiring anything other than voluntary attendance, whether the court is sitting in Kenya or whether the court is sitting in The Hague or indeed in Timbuktu. It's a difference without a legal distinction, and that would be to fall into the, or to be seduced, we would say, by the false dichotomy the prosecution present between transportation and travel and the provisions of the Rome Statute. That is not borne out by the statute, or indeed Article 3, which makes it clear that the court can sit in other locations. Your Honours, if I could go back to Article 93(1)(l), the prosecution say in paragraph 3 of their filing that that provision is to deal with as yet unpredictable types of assistance. Well, appearance of witnesses cannot by any stretch of the imagination, and however desperate one's aim may be, by any contortion of understanding, can be deemed unanticipated. Indeed, there are express provisions dealing with appearance, but it's voluntary, so it's inconvenient. And there's express provisions dealing with video link testimony. So that was clearly in the mind of the drafters of the Rome Statute. To suddenly use Article 93(1)(l), as I said, in the manner put forward by the prosecution, would be to ride a coach and horses through the provisions of the Rome Statute. And, Your Honour, it's paragraph 82, I should say, of the prosecution filing. Your Honour, states, of course, can go further. States can go further. And that's what Germany has done. Germany has done further than that. It's exceeded its Rome Statute obligations. So where, as an exercise of democratic will, a country wishes to include provisions where an individual can be compelled by the sending state to attend, that's a matter of sovereignty in accordance with normal principles of international law. But, Your Honour, that's not what Sweden has done. Because Sweden states that a summons may be binding, but they make it clear in their laws that an individual may not be compelled to attend. Your Honour, that's not novel, because that's precisely what happened in the Special Court for Sierra Leone in the Naomi Campbell case. That court was created under Chapter 6 of the UN Charter. The Secretary-General's report made it clear that unlike the IC2I and ICTR, there was no power to compel third states. It's addressed to the Republic of Sierra Leone. And yet the court issued a summons. The summons was directed at Naomi Campbell, and she, in mandatory language, but of course it was up to, there was no enforcement power in the United Kingdom that could compel her attendance. We say the exact same principle applies here, and it's in our filing that we rely upon. The court can require an individual to attend, but cannot enforce it unless there is legislation and parliaments agree to it. Now, Your Honour...
No, one second. Did you say that the court actually ordered Naomi Campbell to appear as a witness?
Your Honour, the language is at page 7. It's the decision of the 30th of June 2012. And on what it did, it went through a lot of well, not a lot actually, I should be accurate. The conclusive paragraph is at the end, and it respectfully requests the authorities of the state in which Ms. Campbell is residing to assist in the enforcement of this order. Now, Your Honours, the judges in this case did make clear that there had been a Chapter 7 resolution which encouraged states to assist the Special Court for Sierra Leone. That didn't change the Chapter 7 basis upon which the court was created. It was simply encouraging states to assist. But there's no international law obligation that came from that. There's no international law obligation that came from that. Your Honours...
And what happened in that case?
Your Honour, there had been clearly communication between the lawyers for Naomi Campbell and the prosecution, the lawyers, before the decision was promulgated, had indicated that they would accept service. Once there was service, the individual voluntarily came before the court, but was not physically arrested. And, Your Honour, this comes to Your Honour's question to the Attorney General, and I, with respect, part company a little bit. I would underline that the Attorney General did not give a complete concession. He said, I will concede to the question posed about an individual being in The Hague, because it's irrelevant. It wasn't really a considered concession. But, Your Honour, I would go further. If a witness is in this court, if a witness...
No, the Attorney General did not say it was irrelevant. The question to the Attorney General was if a witness, on the theory of the general argument made that there is no power to compel the witness at all. And the question was if the witness chose not to come to court after having been brought to The Hague by the court, can the court not have the power? And the Attorney General considered that point. So let's move on.
Well, Your Honour, he said, I will concede it because it's immaterial. But, Your Honour, I would go further. If a witness today is in the witness room and the witness declines to come to court, Your Honours do not have the power to bring that witness by force to this seat. You do not have the power. There's no statutory article, there's no penalty, there's no power of arrest. Even on these inviolable premises, with an ICC security, if such a witness was strong-armed, that would be an assault, or it would be false arrest. So, Your Honours, if the court does not have the power to do that, upon what basis can the prosecution say it can compel a third state to do something which is not required under its own domestic law? Your Honour, it goes back to the principle of treaties being interpreted in good faith. It would be a regrettable day, and its impact is much greater than this one case, and indeed greater than this court and the Rome Statute, if countries have a reason to show great reticence to sign up to international agreements because a sub-paragraph of a sub-article is used to ride roughshod over what was anticipated in the preparatory conferences. Nobody would have confidence that they would know what they're signing up to, particularly as in this case, the issue of coercive methods and powers to compel were considered and discussed in the preparatory commissions and at Rome, and were excluded. So, Your Honours, we say all those arguments are important. Your Honour...
Mr. Khan, in the Blaskett case, did the appeals chamber not separate enforceability, power to enforce an order, from the ability to make the order itself in the first place? Was that not done in Blaskett?
Indeed, Your Honour, in our filing, what we're saying is there's nothing to prevent the court issuing a summons and, to an individual and requiring Kenya to serve it. So let me be clear. Nothing to stop the court requiring Mr. X to attend the court and requesting or requiring Kenya to serve the document. The articles mentioned by the legal representative deal with...
So you do concede that much?
I concede that much.
That the order can be made?
It can be made.
All right.
But, Your Honour, there is no power in the statute allowing the court to require Kenya to coercively, physically hustle or bustle or arrest and put in the back of a van such a witness when there's no such law.
All right.
Your Honour, important in that regard, if I can say two things. There's other things to say, but two things. The 1959 Act on Mutual Assistance makes it absolutely clear in Article 8 that in cases where an individual does not voluntarily wish to answer a summons, that witness may not be forced to surrender to that summons until and unless that individual enters foot in the jurisdiction of the requesting state. Your Honour, my learned friend has mentioned the 2000 Act, but indeed that, in my respectful submission, supports the defence position. Firstly, of course, it's not acceded to anywhere nearly as widely as the 59 Act. But more importantly, if one could simply say these are implied powers and it's inherent in the powers of a court, why were they expressly mentioned in the 2000 Act? The fact that they've been expressly agreed by like-minded countries in a unique situation like the European Union, trying to get ever closer union, one cannot sensibly, we say, extrapolate from that a principle of wider application, allowing this court to require another sovereign state, not part of a European Union or trade agreement, to compel one of its citizens, absent a law, to attend any premises whatsoever. Your Honour, I think I've taken your time unless I have a few more minutes.
Yes, I was coming to that. Now, why don't we leave it at that and hear from Mr. Kigen-Katwa?
I'm grateful.
Mr. President, on our part, we wish to state that our position is that the Attorney General did not concede that, that this court has powers to compel a witness to come and testify, even if he were in the, even if he was in the hands of a victims unit.
All right, let's get this straight, Mr. Kigen-Katwa. Let's again, let us restate the proposition. You're saying the witness who has been brought to The Hague by the VWU arrives on the day of the testimony for which the witness has been brought. The witness decides, well, it's the sunshine today in the Netherlands, so I'm going to Scheveningen beach to catch some sunshine. I'm not coming to court. And you're saying this court cannot tell VWU, go and tell the witness that we are ordering him to attend the court. Is that what you're saying?
That's what I'm saying, Mr. President. And Mr. President, I wish to proceed and say this, that assuming the court was insistent that that witness must come, and the witness insists that he's not coming, this court can do nothing about it unless it invokes and seeks the assistance of the Dutch government. And that is the point we are making, Mr. President, that this court has no powers to compel a witness to come and testify. We also wish to go on and state, as Mr. Kana said, that if a witness is here and he chooses not to testify, to the extent to which the statute does not give you any consequential powers, what will you do with a witness who chooses not to testify? You have no powers over him. And so even if the witness were in this courtroom and chooses not to testify and is allowed to go home and says the next day is not coming, Mr. President, it is our submission that in view of the provisions of Article 93(1)(e), there is nothing that this court can do. And it is on those premises, Mr. President, that we are saying that any interpretation that will be made by this court to say that the Kenya government is compellable to procure the attendance and the adduction of evidence by a witness would be an interpretation that has not been done in good faith, and considering the provisions of Article 22, Article 21, subsection 3, that the evidence has to be voluntary. Article 21(3), Your Honours, is to this effect. The application and interpretation of law pursuant to this article must be consistent with internationally recognized human rights and be without any adverse distinction founded on grounds such as gender, as defined in Article 7, paragraph 3, age, race, color, religion, belief, political opinion, national, ethnic, or social origin. And, Mr. President, it proceeds to say that the interpretation must be made in favor of the accused persons. Mr. President, if you were to insist that you have powers to compel a witness, it would require you to struggle and explain away the use of the word require and replace it with the word order. And, Mr. President, we maintain our submissions that we made originally, that when the drafters used the word require, they deliberately chose not to use the word order, and it cannot be read that or implied that it was lack of consciousness that they used the word require as opposed to order.
And Mr. Kigen-Katwa, you standing there at saying that the word require means request. Is that what you're saying?
I would say this for myself, Mr. President, that the word require must be derived from the word request.
All right, go on.
Mr. President, if you were to say that the Kenya government is compellable to procure the attendance of the witness, you would also have to struggle, and we must say, Mr. President, it is our submission, that it would be an artificial argument to say that Article 93(1)(e), using the word voluntary, is redundant or is useless or can be overlooked. Mr. President, Article 93(1)L, which has been invoked by the prosecution to tell you that you have those powers, uses the word other. And very specifically, Mr. President, this is how the words are used at Article 93(1). Any other type of assistance which is not prohibited by the law of the requested state with a view to facilitating investigations and so on and so forth.
All right. Now, why would summons to a witness and requesting a state party to enforce summons to a witness not qualify as any other request?
Mr. President, that is a point which is already considered, and we concede also that the powers of this court to request the Kenya government to serve summons is not contested. That request can be made. We, however, draw the distinction between the mere act of serving the summons from compellability of a witness to testify.
That's the point. Hold on. The point is, why would requesting a state to compel the attendance of a witness to whom summons haven't served, why would that not qualify as any other request of the state that may be made and that should be honored by the state?
It is actually our argument that it is not other because it is provided for. The service of the summons does not fall here in terms of other.
Having that request executed, as in with state A, we require this witness to attend. It is our view that require means order. We want you to make sure this witness attends using your local processes. Why can that not be something that falls within Article 93(1)L in terms of any other request?
Mr. President, the issue starts from the question you posed to the Attorney General, and which we would also want to answer on our part, as to the extent and the scope of the purpose and the import of the word summons. Mr. President, you had asked the Attorney General whether summons does not in itself incorporate a compulsive power, a compulsive obligation on the person to whom the summons are addressed to attend. It is our argument, Mr. President, it is our submission that summons is a mere notice to an individual that is required on a given day at a certain address. If that individual chooses not to attend, there are separate processes which will determine, first of all, the viability and the legitimacy of those summons, and whether, in fact, the act of that individual amounts to violation or disobedience of an order. And so, Mr. President and Your Honors, we submit that the mere service of a document indicating to an individual that is required at a certain address does not necessarily amount in itself, or in other words, does not in itself incorporate the obligation that he must attend, Mr. President. It is, and when the government, may I explain, Mr. President and Your Honors, that it is our understanding that when Kenya government is serving the summons, it is merely telling the individual that we have received a request from the ICC saying, you are required at this address on a given date. That is the end of that issue. It is for the witness to determine whether he wants to come or not.
Does that also relate to, is that the case as well, if we are operating under Article 93(1)B, where the request is for a judge in a national jurisdiction to take the evidence on behalf of the ICC?
That is our position, Mr. President, because Article 93(1)E says that that testimony has to be voluntary. Mr. President, we insist, we maintain, we submit that 93(1) here has to be given meaning.
Mr. King-Katwa, can you also explain give your own answer to a question that Mr. Nderitu had answered? And the question was this, so the point was this. In Kenya, a court sitting in a theft case can compel a witness to attend the criminal case involving common theft. But from your argument, it would seem that that court may not be able to, if I'm wrong, correct me, compel a witness to appear in a genocide trial. Is that your point?
Mr. President, if the trial were being conducted in Kenya and by a Kenyan court under the Criminal Procedure Code, with a few exceptions, it is possible for the witness to be compelled. And even that law itself is not absolute. It's not like every witness is compellable. Mr. President, we insist that there is a distinction between the International Criminal Court conducting proceedings under the Rome Statute and under the ICA as domesticating the ICC, the Rome Statute in Kenya. There's a distinction on one part from that as opposed to a Kenyan court conducting proceedings under the Criminal Procedure Code. And there is a very definite barrier when the ICA at section 86 to 91 says that the witness has to adduce his evidence voluntarily, Mr. President. Mr. President, at this point...
What I'm saying is this. Are you saying that a criminal case being conducted, a genocide case being conducted before a Kenyan court, can that court not compel the witness to appear? Is that what you're saying? In a genocide case being conducted before a Kenyan court, can the court or not compel a witness to appear?
Mr. President, I would prefer to answer my question not so much as to the physical or the geographical location where the proceedings are conducted. I would rather answer the question as to which regime of the law is being...
That's how you need to answer it then. Can you, let's say, under what regime would the court be able to, in that sort of, in a genocide trial, compel the attendance of a witness? And under what regime may the same court, the Kenyan court, not be able to compel a witness to appear in a genocide trial?
Mr. President, if the proceedings are being conducted under the Criminal Procedure Code, Kenya, then the witness is compellable unless he falls under the exceptions that are provided for. However, if the proceedings are being conducted, even if it is in Kenya or by video link, and the proceedings are being conducted under the Rome Statute.
No, by a Kenyan court. Forget about the ICC now.
Even if it is by Kenyan court, but using the Rome Statute, assuming one of the three of you were a Kenyan judge, you would not be in a position to compel a witness to come and testify because you are prohibited by the state parties through the provisions of Article 93(1)(e). It is an absolute barrier, Mr. President, and Your Honors. That's our submission. And Mr. President, the Kenyan Parliament very consciously and deliberately said that if a Kenyan citizen is to come and testify before this court, he has to be voluntary. It goes on to say, Mr. President, that the Attorney General must satisfy himself that that witness is coming to testify voluntarily. Mr. President, we submit that that in itself creates some rights for that individual, which are not being discussed in this court. That individual has a right to exercise his choice whether to come here voluntarily or not, Mr. President. And that informs the issue that surrounds both the ICA and the Rome Statute, Mr. President. Nobody is discussing the questions of if that witness doesn't come here, what will you do? What will this court do? What will the Attorney General do? The law does not say what consequences will follow such individual if he chooses not to come, Mr. President. And we submit, therefore, that the coming is a question that is voluntary, Mr. President. Mr. President, we would want still to insist that before you come to the questions of whether or not, as posed by yourself, the question first of all is whether this court can compel the attendance of the witness, and secondly, whether this court can create either a duty or a legitimate expectation on Kenya to procure the attendance of the witnesses. Mr. President, we pray that the court keeps in mind that it has to identify some criteria which the prosecution has to satisfy before coming to the point of saying we need to procure the attendance of this witness. And Mr. President, we resubmit that the criteria used in ICTY and ICTR may be relevant. The first one is that that evidence is necessary. The second one is that that evidence is material. The third one is that it is not obtainable otherwise. And lastly, Mr. President, that reasonable attempts have been made by the prosecution. Mr. President, may I say, when I'm on my feet, that the prosecution have completely not satisfied those criteria.
Thank you. Now, let's go back to the prosecutor. And prosecutor, if you can take us to the end of the morning break, we'll end it there. Can you please begin with the question, the last point raised by Mr. Kigen Katwa, which also I had flagged to you earlier when Mr. Ken made his submissions on Friday, about the reason why we must do this in practical terms, quite apart from the law of it. Is this an academic exercise when we compel a witness to attend, a witness who not only, their point is not, sorry, I'm not coming anymore, I don't want to come, I don't like lawyers and judges. But the witness's position is, well, I lied when I spoke before, I recanted. Why should we bother?
Mr. President, I fear you won't hear much from me then. I had hoped to tidy up issues that have been canvassed over hours on Friday and again this morning. However, I will follow your indication and mention just very briefly certain cases, certain judgments from the ICTY, and then I will defer to Mr. Steinberg, who can give you a much better picture of why it is indeed very worthwhile to consider what we're asking. Now, if I have a moment after that to deal with the other issues that I had hoped to address with you, I'll be grateful for the opportunity, but I'm in your hands. The ICTY Appeals Chamber, in its judgment in Popovich, and I can give the citation later, accepted the flexible approach taken by the trial chamber in Kraishnik. And once again, I can give the reference later rather than take up time doing it now, in which the trial chamber was disposed to take a more flexible approach than that which might obtain in purely common law jurisdictions, and determine on a case-by-case basis whether to allow the prosecution to put questions in a more leading way to a witness and on which issues. And the trial chamber's ruling arose in the context of the prosecution's notification that it was calling witnesses who could be potentially adverse to its case. Mr. Steinberg, however, can explain in general terms, realizing that we're in a public setting, why in the view of the prosecution it is entirely worthwhile to pursue this remedy. Thank you.
Steinberg, can you do that in 5 minutes?
I believe I can, Your Honours. Your Honours, my learned friend Mr. Khan raised essentially two objections regarding the forensic utility of calling or following the procedure requested by the prosecution. The first relates to the ethical issue of calling evidence which the calling party knows to be false, and the second is relating to the utility of calling a witness who may be expected to recant his version. And I refer to real-time transcript 87 from page 28, line 17 onwards. In relation to the first issue, Your Honours, I can categorically state that the prosecution has a good faith basis for its belief that the original statements deposed to by these witnesses represent truthful accounts, and that any subsequent denials or recantations are false. The original statements were all given voluntarily by the witness, having been properly cautioned and interviewed over several hours or days. In addition, in the case of 5 of the 7 relevant witnesses, these statements were also audio recorded, giving further safeguards against any improper influence. On the other side of the equation, the prosecution has evidence in the case of each of these 7 witnesses of intimidation, bribery, or other improper influence, which has, in the prosecution's submission, been the proximate cause of their ceasing to cooperate with the Office of the Prosecutor. This has been set out in some detail in the ex parte version of the prosecution's original request. In relation to the second objection, my first response is that it is entirely speculative. At the outset, it should be noticed that only 3 of the 7 witnesses have in fact recounted their earlier statements. In regard, that is witnesses P15, P16, and P336. In respect of the remaining 4 witnesses, they have simply refused to testify but have not disavowed their prior statements. Thus, there is no reason to believe that if their attendance may be secured, they will not confirm their earlier statements. Even, however, with respect to the remaining 3 witnesses, as Your Honour pointed out on Friday, Mr. President, one cannot simply assume they will maintain this position if their attendance may be secured. It may well be that in the solemn atmosphere of this courtroom, removed from any undue influence and under peril of prosecution for perjury, they may well decide to tell what we say is the truth and confirm their original statements. One might say that recantations made in the media are cheap. To do so under under pain of perjury is a different matter altogether. However, even assuming that these witnesses will recant, there are at least still at least 2 legitimate forensic purposes for calling them. The first is that their evidence will assist this chamber one way or another to resolve what is becoming a central issue in this case, namely whether, as the defense alleges, several important prosecution witnesses are part of a deliberate and concerted scheme to cook evidence against the accused, or, on the contrary, whether there exists a deliberate and concerted scheme to intimidate or corrupt prosecution witnesses to recant or otherwise withdraw their testimony. The allegedly colluding witnesses are said to include 3 of the 7 witnesses relevant to this prosecution request, again witnesses P15, 16, and 336. I note that the defense for Mr. Ruto argued in filing number 818 that it was in the interests of justice to call these witnesses at the earliest possible opportunity in order to get to the bottom of these allegations. This request was also joined by the Sang defense team, who additionally requested the calling of witness 524, also relevant to this request. This is despite the fact, I might point out, that one of these witnesses, P15, had already deposed to an affidavit recanting his original statement, which appeared to cause the defense no disquiet at that time. Secondly, Your Honours, the rules of procedure and evidence provide another important forensic purpose for calling these witnesses, even if they are expected to recant, in circumstances where their change of testimony may have been materially influenced by improper interference, as the prosecution alleges. I refer, Your Honours, to Rule 68(2)(d), which permits, subject to certain conditions, the introduction of prior recorded testimony of a witness who has been subject to interference and who either fails to attend or, having attended, fails to give evidence with respect to material aspect of his or her prior recorded testimony. The prosecution submits that should any of the witnesses indeed fail to confirm their prior statements, they may be questioned as to the reasons for this, which would put the chamber in our submission in a far better position. Thus, Your Honours, to sum up, the defence objection is with respect both speculative and misguided and should not prevent the court from granting the request.
Thank you very much.
President, with your...
Mr. Khan, no more from you. We've done. We will rise now. We've heard your, Mr. Kigen-Katwa. We will end this debate. When we come back, Mr. Stewart will have 5 minutes to round up what he said he needed to round up, and we will leave it at that. And we will yes, why don't we leave it at that for now? There has to be an end to litigation. We'll rise now and come back at 11:30.
All rise. We will wait.